So if you were sold a revocable trust, a family trust, and your main primary purpose was to avoid probate, you might have been oversold. Actually, it would even be appropriate because there's actually ways in which you can get your assets to have beneficiary clauses. So there's a thing called a POD, payable on death. That's for your bank accounts. You can also have what's called a transfer on death, or TOD, for your brokerage accounts. Remember, IRAs, annuities, life insurance, they all have beneficiary clauses. Those supersede any wills or trust. So although you have a trust and you have that in place, that isn't necessarily the main purpose for, quote, avoiding probate, because you can avoid probate other ways. And so people also think that revocable trust or family trusts are asset protected. It's not true. They do not protect your assets. What they do is they can keep things private. So when you pass away or you become incapacitated, and how assets flow, that could be totally private. And you can't do that with a will. A will is registered and people will see stuff that goes on, and wills can be public domain, and the family trust can be private. Another problem with family trust is a lot of times I've seen people who have not actually taken the asset and funded their joint account over into the name of the trust and get that funded. And sometimes people do it because of cost, because of confusion, laziness, forgot, something happened and it just didn't come together. So it needs to be funded into the trust to get the benefits of that distribution and allocation. Remember, beneficiaries could change. The allocation for that could change. You may have some minor children, and then once they're of majority age, you may have one that's doing great and you say, hey, I can let them be the successor trustee, or I can let them go ahead and get their money at age 25. But, for this other child, I may not want to do that. And so you love your children equally, okay? But you need to treat them uniquely because of that. And so what I mean is that you have to consider they don't know how to handle their own money. Some of them would not know how to handle their own money. So there's some preparation that can be done in that regards. Revocable trust do not address end-of-life planning. So if you're thinking about Medicaid and you've got, mom goes into a nursing home and now it's $30,000 a month. Well, you're going to blow through assets, and the family trust will never do anything to actually help protect any of those assets. It's not asset protection, and it's definitely not going to help you go get Medicaid. You're going to have to blow through your assets. People don't know that. You need to have an irrevocable trust that addresses that. Same thing with VA benefits. In 2019, the number is $127,000, not counting your house and your automobile. So if you wanted to apply, you're a wartime veteran or the surviving spouse of a wartime veteran, you want to collect money from the VA to help pay for custodial costs like assisted living, nursing, and those types of things. You could not do that with a family trust. It needs to be an irrevocable trust. Let me tell you last, I'm not an attorney. But 3 decades of lots of conversations, of sitting in offices with attorneys, watching them explain the trust and what it does and what it doesn't do. I have a lot of experience and knowledge about how these things work. And if you'd like to review with me, you'd like to sit down and have a conversation, I'd be welcome to talk with you about that. Thank you.